India Legal presents Courts Roundup.
Hello, I'm Isha and you're watching Courts Roundup. In this program, we bring you the latest legal news and details of court proceedings. And before we begin, here's the headlines. Delhi High Court rules no more extension of interim orders in civil cases. Under trials in heinous cases will have to surrender. In the case of gang rape of a law student, Karnataka High Court upholds life sentence for 7 convicts, says this is no less than Nirbhaya case, recommend death penalty for gang rape. Karnataka High Court grants bail to sitting MLA's nephew whose Facebook post has sparked Bangalore riots. Petitioner contended that he had merely forwarded the post and later withdrew the same. Allahabad High Court orders police protection for Phoolpur gang rape victim, warns against wrong petitions and asks Senior Supretendent of Police to take strict action against the negligent police officers in probe.
India Legal presents Courts Roundup.
Delhi High Court has passed an order holding that there will be no more extension of interim orders in civil cases. Court has said that under trials in heinous cases have to surrender. The court has ordered that all interim orders passed in the civil matter shall cease to have an effect on the next date of hearing in the said matter. The extension order were passed in the view of COVID situation.
The Delhi High Court has modified its earlier order on extension of interim bail orders on account of COVID-19. The court has also ordered that all interim orders passed in the civil matter shall cease to have an effect on the next date of hearing in the said matter. A 3-judge bench of Chief Justice D.N. Patel, Justice Siddharth Mridul and Justice Talwant Singh had passed the order. For 2,318 under trial, who are involved in heinous crimes and were granted interim bail by the district court, there shall be no further extension of interim bails under the order of this court. Such under trials are ordered to surrender in a phased manner from 2nd November onwards. All 356 prisoners who were granted interim bail by the High Court are ordered to surrender on 13th November 2020. The High Court has clarified that the under trial are at liberty to move the prospective courts for extension of their interim bails, and the concerned court shall consider the said application for extension of interim bails on its own merit and take a decision accordingly without being influenced by any order passed by this court in the past. For 2,907 prisoners who were granted bail on the recommendation of High Power Committee, a request has been made to the High Power Committee to take a decision on the issue within 10 days. The court has directed the jail authorities to make appropriate arrangement to ensure surrender of the prisoners and take all required steps in the view of the guidelines issued by the government authorities from time to time to contain the spread of coronavirus. For civil matter as well, the court has clarified that the parties are at liberty to move the concerned court for extension of the interim orders. On 25th March, the High Court had passed an order extending the life of interim orders, which were subsisting as on 16th March and were likely to expire or had already expired till 15th May 2020. Subsequently, as the limited functioning of the court continued, the life of interim orders was given 3 extensions. The latest extension was set to expire on 31st October. Bureau Report.
And while denying a bail to an accused who has been booked for damaging a mosque during the February communal riots in northeast Delhi, the Karnataka Court recently observed in recent communal riots in northeast Delhi, more than 50 innocent people were killed by the rioters, and the dastardly act of rioters in this matter is an act against the country's secular structure. The additional session judge Vinod Yadav further observed, considering the gravity of allegations, large-scale involvement of the applicant in cases of riots, I do not find it to be a fit case for grant of bail to the applicant. Before taking up the argument of the prosecution, the court noted that this was the fifth bail application filed on behalf of the applicant. The counsel for the applicant vehemently argued before the court that the application was falsely implicated in the matter. The special PP for the state vehemently argued that the present case was a very serious matter wherein the rioters had caused destruction at Fatima Masjid. It was further argued that the applicant was clearly identified as one of the members of unlawful assembly who had caused damage to the Fatima Masjid, namely Mehboob Alam and Akram. The Delhi High Court, while hearing a case related to child pornography, has directed the police agencies to forward sexually explicit materials relating to the petitioner to the National Crime Records Bureau to identify the person who are re-uploading the offensive content in India. The bench had also directed the social media platform to use such measures as available with them to remove the contents which are similar to the contents of the URLs in the present case. A single judge bench led by Justice Bhivu Bakhru was hearing a petition by a 24-year-old woman whose photographs, which had been taken when she was a minor, had been uploaded on the internet by her boyfriend. Advocate Anurag Ahluwalia, learned counsel appearing for the Government of India, submitted that NCRB acts as a nodal agency for technical and operational functions of online cyber reporting portal www.cybercrime.gov.in. The incident reported on the portal was shared with the law enforcement agencies. NCRB has also entered into a memorandum of understanding with NCMEC to receive cyber tip line reports relating to the suspected CP content. Facebook, through an affidavit, submitted that it has implemented a number of measures to combat the spread of child porn, including working with National Center for Missing and Exploited Children, which is a non-profit organization involved in helping to find missing children, reduce child sexual exploitation, and prevent child victimization. The Delhi High Court has granted an interim relief to Times Now while restraining Republic TV from using the trademark News Hour or any other mark that may be deceptively similar to it. The court, however, refused to grant any interim relief with respect to use of the tagline "Nation wants to know," stating that a detailed examination of the issue is required. The partial relief of the interim injunction was granted in favor of the Bennett Coleman and Company, the parent company of the channel Times Now, by a single judge bench of Justice Jayant Nath. The media conglomerate had moved the High Court seeking a permanent injunction against Arnav Goswami's ARG Media Outlier and from using the mark News Hour and Nation Wants to Know or any other derivatives or combination of the same. The dispute between the Times Group and Republic Network over this has its genesis in anchor editor Arnav Goswami's exit from Times Now in 2016 to set up his own venture ARG Outlier Media Limited, of which the Republic Network is a product. During Goswami's time in Times Now as its editor-in-chief, the channel launched one of its flagship debate discussion program titled News Hour in 2006. The trademark News Hour was registered by the Times Group. As regard to the phrase "Nation wants to know," Times Group claims that this tagline was a product of the efforts of the editorial and marketing team during the creative efforts undertaken for and on behalf of the plaintiff group. BJP leader Pradyumna Singh Tomar has challenged the October 20th order of the Madhya Pradesh High Court, which directed that political parties shall conduct election campaigns by virtual mode without physical gathering. Tomar, who is contesting by-election from Gwalior, seeks a stay on the order, contending that it violates its right to conduct election campaign through physical gathering as permitted by the Election Commission of India. The Madhya Pradesh High Court had directed the district magistrate of Datia and Gwalior to ensure that FIRs were registered against former Chief Minister Kamal Nath and Union Minister Narendra Singh Tomar for alleged violation of COVID-19 norms during election campaigns. The High Court has passed orders in a PIL highlighting that various political parties were organizing physical campaigning, which was increasing the spread of COVID-19. It was contended in the plea that state authorities were not taking any action against such political parties and their leaders. It is in the impugned order, the High Court directed that political parties shall conduct the election campaign by virtual mode and not by physical gathering. It further restrained the district magistrate of all districts from issuing any permission to conduct physical campaigning unless it could be proved that conduct a virtual election campaign is not possible. The High Court had further directed that the permission of the district magistrate for physical election campaign shall be effective only if the Election Commission of India approves the same in writing. And now it's time for a short break. We'll be right back.
India Legal presents Courts Roundup.
क्या उफ गर्मी फोन तो नहीं है ना
India Legal presents Courts Roundup.
Welcome back. The Karnataka High Court has confirmed the life sentence awarded by a trial court to 7 people involved in the gang rape of a law student. The court has suggested that a law should be framed at the national level prescribing death penalty for the gang rape of a woman. A division bench of Justice B. Vedappa and Justice K. Natharanjan upheld the order passed by the trial court in September 2013 and 2017, sentencing the accused to life imprisonment and dismissed their appeals. The court made the observation while upholding the life imprisonment imposed by the trial court on 7 convicted persons who had gang raped a 21-year-old law student near Jana Bharati campus in the city on October 13, 2012. Observing that though Indian Penal Code was enacted by Act 45 of 1860 and even after lapse of 74 years of independence, still women is not safe in the hands of rapists, violators of the law. The Karnataka High Court has recommended amendment to Section 376D of Indian Penal Code to provide capital punishment for the offence of gang rape. A division bench of Justice B. Verappa and Justice K. Natharanjan made the recommendation in their judgment while upholding the life sentence imposed on 7 accused of gang raping a student of National Law School of India University in 2012. Court said rape is not only an offence against victim girl but a crime against the entire society. It is a crime against basic human rights and also violates the most cherished fundamental right guaranteed under Article 21 of the Indian Constitution. On 13th of October 2012, when the victim girl and her friend were talking to each other in a parked car, all of a sudden all the accused person surrounded the cars and said, car holding deadly weapons like iron rods, seesaw, long knives, daggers and rope in their hands and committed the act. The Karnataka High Court has granted bail to the nephew of a sitting MLA who was accused of uploading a derogatory Facebook post, which ultimately led to Bangalore riot in August 11th. A single bench judge of Justice B. A. Patel granted bail to the petitioner while imposing the following condition: to execute a personal bond of 2 lakh rupees along with 2 sureties and to refrain from tampering with prosecution evidence and to mark attendance before jurisdictional police every month. To not leave the jurisdiction of the court without prior permission. Seeking bail, the petitioner contended that he had merely forwarded the post and later withdrew the same. It was his further that contention that with a political motive a false complaint was registered against him. Opposing his bail, the prosecution contended that the post shared by the petitioner had created disturbance in the said locality. The riot had resulted in 2 police stations and 57 police vehicles being burned by an angry mob. It was further argued that there is a threat to the life of petitioner himself if he is released on bail. It was also contended that the petitioner was an habitual offender and that there were 7 cases registered against him. The court also found no substance in the prosecution's contention that the petitioner's life would be in danger if granted bail. With this observation, the bench proceeded to grant bail to the petitioner. And the Rajasthan High Court has stayed the proceeding by a CBI court which had ordered reopening of a probe against former disinvestment minister Arun Shourie and 4 others over the sale of a government-owned hotel in Udaipur 2 decades back. The Jodhpur bench of the High Court has summoned records of the case from the special CBI court, asking it not to proceed against Arun Shourie and 4 others until further orders. Hearing the case, Justice Vijay Vishnoi ordered that the trial court shall not proceed against the petitioner pursuant to the impugned order till further orders. Appearing through video conferencing, Shourie said the process of disinvestment of Lakshmi Villas Hotel has been challenged twice by the same person before the division bench of the Rajasthan High Court, but was dismissed both times, that is in 2002 and 2006. Last month, the special CBI court ordered the registration of a new FIR against former Union Disinvestment Minister Arun Shourie and then Department Secretary Pradeep Baijal, Lazard India Limited Managing Director Ashish Goha, valuer Kanti Lal Karamse and Bharat Hotels Director Joshna Suri over the sale. And the Uttarakhand High Court has issued show cause notice to a top official in a civil contempt petition to ascertain as to how he lowered the amount to be recovered from present Union HRD Minister and ex-Chief Minister of Uttarakhand, Ramesh Pokhriyal Nishank. The bench of Justice Sharad Kumar Sharma was hearing a contempt petition wherein the judgment of the direction contained therein was sought to be complied with. As far as Ramesh Pokhriyal Nishank's case was concerned, the court noted that he was communicated by the Additional Secretary, a state officer of the government of Uttarakhand, of the amount of liability due to be paid, and consequently whatsoever amount was demanded, he remitted the same. Hence, according to the argument of the counsel for the respondent Ramesh Pokhriyal Nishank, the judgment stood complied with on his part. But the petitioner's counsel submitted that the determination of the amount made by Mr. Dipender Kumar Chaudhary, Additional Secretary to the Government of Uttarakhand, would in itself amount to be a contempt of criminal nature. Notably, in June 2020, the Uttarakhand High Court had declared that the Uttarakhand former Chief Minister Facility Act 2019, which allowed former Chief Minister of the state to stay in government bungalows without paying market rent, was ultra-virus. The division bench comprised of Chief Justice Ramesh Ranganathan and Justice R.C. Khulbe had held that the Chief Minister, once he demits office, is on par with the common man and is not entitled to any preferential treatment other than security and other protocols. And adding to the legal woes faced by actress Kangana Ranaut for her controversial tweet, criminal complaint has now been filed before the Metropolitan Magistrate in Andheri, Mumbai. The compliant advocate Ali Khasif Khan Deshmukh has asked the court to take cognizance and issue process against Ranaut for allegedly committing offence under Section 121, 121A, attempting to wage war against the government, Section 124, sedition, and Section 505, related to spreading enmity and hatred amongst different religious groups of the Indian Penal Code. The complaint states, it is pertinent to note that every Indian citizen has got the right to freedom of speech and not the freedom of hate speech. Deshmukh has alleged in his complaint that Ranaut had been putting up comments against the government of Maharashtra and executive missionaries like the ministers and Mumbai police on hot Twitter handle. He added that Ranaut has time and again put up a statement on hot Twitter handle with malified intention and ulterior motives of creating an atmosphere of hatred in the country amongst different religious groups. And the Patna High Court has recently acquitted a rape and murder accused, thereby setting aside a death sentence awarded by the trial court for lack of cogent reasons. The bench of Chief Justice Sanjay Karol and S. Kumar pronounced judgment in the matter, taking note of the fact that the prosecution evidence seemed to be founded on hearsay. The court recorded its dissatisfaction with lower court's finding that the offence warranted the death penalty. The appellate, Ajit Kumar, was convicted by a trial court under provision of the Indian Penal Code and the Protection of Children from Sexual Offence Act 2012 for the kidnap and rape of a minor. As per the prosecution's account, the appellant and another entist kidnapped a minor and set her on fire after sexually assaulting her. The prosecution had at first averred that the girl had poured kerosene on herself and died thereby. The bench noted that the trial court did not furnish cogent reasons to conclude that the appellant deserved the death penalty in the 9 pages it had devoted to condemning him. The High Court noted the existence of the confessional statement was that weighed with the learned judge for convicting the accused, but its relevance or admissibility was never considered and examined, the bench remarked. Pertinently, the court found that the evidence on hand did not indicate that the deceased minor had been the victim of a sexual assault. On the issue of sexual assault, there is no evidence at all. The Allahabad High Court has directed the Senior Superintendent of Police of Prayagraj to provide security to the gang rape victim of Phoolpur and her family. At the same time, the court has directed the SSP to monitor the investigation of the case on its own and take strict action against the negligent police officer. The court has said that FIR should be immediately registered for every criminal incident, especially crimes against women and children. A bench of Justice Shashi Kant Gupta and Justice Pankaj Bhatia was hearing the petition filed by the rape victim. The court has said that the police officers who did not register a complaint of the victim for 3 months and are now negligent in deliberation. Government must have to take strict action against them. The victim's mother had filed an application in the High Court stating that the police had kept the victim in the police station and was not allowing the family members to meet. On this, the court had ordered the victim to appear in the court. And that's it for Courts Roundup. Thank you for watching.
India Legal presents Courts Roundup.